Silicon Flatirons is a research center at Colorado Law School. We work with students to give them the tools they need to pursue careers in tech, law, policy, and entrepreneurship.
When I started, Silicon Flatirons was an experiment. It was me and some students putting on a few conferences without really a plan where it was going to go. My initial motivation was because I didn't believe you could have impactful policy discussions unless you brought people together across different disciplines. Silicon Flatirons Center has given me an image of what a team can look like.
And it really made Boulder into a location that was seen as on par with DC or Silicon Valley and other places around the country that are leading thought centers in the field of law and tech.
What's excited me the most is to see it grow, but not only just grow in terms of the number of people attending our different events, but growing in terms of the different areas that we have been involved in.
When a law student says, I've got a passion for understanding the intersection of technology and law, but where do I get started with that? What Flatirons provides is a position to actually go angle for a job during their second summer, where they're actually going to get to be involved directly in setting tech policy or in advocating around tech policy.
The Silicon Flatirons community is incredibly unique in how close it is and how people are willing to band together to move conversations forward.
It's one thing to be sitting in a room by yourself reading articles, and it's very much another thing to actually be sitting at a table talking to somebody about their daily experiences of trying to navigate compliance with the complex new law.
We're all a community of friends who enjoy spending time with one another.
The people we engage with through here are very much thinkers and thought leaders, so they're contributing to whether it's our strategy or our resources in really meaningful ways.
Silicon Flatirons has changed the dynamic between Colorado law and the surrounding community as well as the national community.
One of the great joys of my profession is talking to people who are really early in their careers and helping them get excited about what you're excited about.
We get the types of people in the room that everyone thinks should be talking to one another, but often are not.
I get to work with students, I get to work with attorneys, I get to work with policymakers at the intersection of all these issues.
Students are first and foremost, so everything is generally student-driven.
And it is centered around people who are wanting to engage with students.
I've seen students come into Silicon Flatirons just having a little interest in it, in year one, and by year three, they're passionate about it and they found their career.
And I think that really helps the standing of the university more broadly, and it also attracts lots of really interesting and talented speakers.
I think what I'm excited to see happen with Silicon Flatirons in the next 5, 10, even 20 years is for it to blend continuity with change.
It's not enough to have smaller conversations anymore. The world is all connected, and Silicon Flatirons is going to reflect that global nature of the internet as we move forward into 20 years in the future.
I hope it continues to operate with the same spirit of experimentation, of adventure, of seeking out new challenges that we've done over the first 20 years.
Good afternoon, everybody. My name is Amie Stepanovich, and I'm the Executive Director of Silicon Flatirons, and I'm so honored to be able to welcome you here with us today virtually. I can't wait till we can be back together in the same room, when I can connect with you one-on-one and hear more about what you're thinking about or what you're working on. It's been a great inspiration to me to see that sense of shared community that's present at every one of our events that I attend. And I'm so glad we can continue in that tradition, even when we're not together. If this is your first Silicon Flatirons event, I welcome you. Silicon Flatirons has a mission to elevate the debate around technology law, policy, and entrepreneurship, to spark tomorrow's conversations through intellectually honest programming and community engagement. I want to thank our staff, our speakers, and our full community for helping to inspire and execute the programming that you're going to see here today. And a special thank you to our supporters. It was so important to us to be able to provide the programming you're about to see free of charge, so that it could be accessible by anyone, regardless of any hardship they may be facing. We're so appreciative of our supporters' generosity, so we can continue to serve our full community. If you enjoy today's program and you want to help us create more like it, and if you have the means, we would welcome a donation to Silicon Flatirons today. Every dollar you make has a long and lasting impact. And if you'd like to help us, you can go to siliconflatirons.org and click on the donate button. Thank you again so much for joining us, and I hope you enjoy today's program.
Good afternoon, everybody. Thank you so much for coming and joining with us today. It turns out that virtual environments allow the fastest costume changes possible, which is really exciting. And we've been really trying to take advantage of this new virtual space to provide new and exciting programming for you all. And I'm super enthused about the speakers that we have today. As has been mentioned, my name is Amie Stepanovich. I am the Executive Director of Silicon Flatirons and also the moderator for today's session. Before we get started, I do want to point out two things. One is the Q&A button at the bottom of your screen. If you have a question to ask, please drop it into that window and not into the normal chat so we can keep track of actual questions that we have coming in, and we'll get to those later in the conversation. In addition, after this panel, you'll receive via email a survey about the event as well as a link to your CLE certificate. So if you're looking for that, it will be sent straight to your inbox. So keep a lookout for that. And finally, if you go to the event website, you're going to see a link to some of the resources that will appear on screen today. So if you'd like to download those and have them accessible to you, they're on the event page, which is accessible through siliconflatirons.org. So without further ado, I want to get right into the conversation. And I find it really interesting that today, when I opened up my Politico morning newsletter, one of the top articles was about a survey from BitGlass on remote work. And from the story, it said that more than 8 in 10 organizations consider it likely that they'll continue to support working from home. However, 41% said they hadn't taken steps to expand secure access for remote work. Half said that they lack the proper equipment, and 65% said they will allow access from personal unmanaged devices, even though 55% said they consider it a significant security risk. So these are some things that we'll be talking about today, and I want to get straight into the conversation with our 3 panelists. Their full bios are again linkable from the event website, but to introduce them in short, we have Melanie Kay, who is the director of the Daniels Fund Ethics Initiative Collegiate Program at Colorado Law. The initiative focuses on helping law students develop strong ethical professional identities through a variety of programming and opportunities. And she has more than 10 years prior experience in litigation, including at Earth Justice. After Melanie, we'll turn to Marc Zwillinger, the founder and managing member of ZwillGen PLLC. Marc counsels on issues related to the laws governing internet practices and helps clients with compliance obligations pertaining to the use and disclosure of customer and subscriber information. And fun fact, he's also the only private attorney known to have appeared before the Foreign Intelligence Surveillance Court of Review. And finally, we'll go to John Verde, the Vice President of Policy at the Future of Privacy Forum. John supervises FPF's policy portfolio, which advances FPF's agenda on a broad range of issues. And he previously served as the Director of Privacy Initiatives at the National Telecommunications and Information Administration, or for those of you who practice in acronyms, NTIA. So I'll turn it straight over to Melanie. Thank you.
Great, thanks so much for having me. It's a pleasure to be here with everyone. So as part of my role as the director of the Daniels Fund Ethics Initiative here at Colorado Law, I also teach our legal ethics courses to law students. And so today I'm going to highlight some of attorneys' ethical obligations under the rules of professional conduct in remote work environments and during this pandemic. So the short story, just to really cut to the chase, if you want to tune me out for the next 7 minutes, is really your ethical obligations do not change one bit during times like this. That means that if you are working remotely, if your court appearances have been delayed, if your filings have been delayed, if you have children running all over the house and a million other distractions, you are still held accountable to comply with the rules of professional conduct in your state And of course, also, greater ethical obligations to your clients, to your coworkers, to the court system in general, of upholding accountability, trust, respect, your integrity, things like that. So today what I want to do is highlight a couple of those rules that I think are really pertinent during this time, and maybe you haven't been sort of digging deep into the rules lately, and so this will be a bit of a refresher on a couple of those rules that I think are really relevant and important, and I will let the other experts on the panel dive into what that means in terms of technology and privacy and security. So the first rules I want to highlight are about competence and confidentiality. I'll then dive into diligence and communication and briefly touch on supervision before a final comment on professionalism. So as you likely know, under Rule 1.1 regarding competence, you need to have the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation you're engaging in. There's a comment to the rules, comment 8, that addresses technology, that requires you to keep abreast of changes in law and practice, including the benefits and risks of relevant technology. What that really means is you cannot hide in the sand and say you hate technology and that you can avoid having to learn about these new platforms, new methods of communication that we've all been hastily required to get up to speed on and learn how to use during these times. As you can imagine, one of the biggest risks with learning about these and trying new things is we have to uphold our confidentiality obligations. There is a Pennsylvania ethics opinion that came out relating to specifically to working remotely during the COVID pandemic that notes a lawyer's duty to provide competent representation includes the obligation to understand the risks and benefits of technology, which in turn includes the obligation to understand or take reasonable measures to use appropriate technology to protect the confidentiality of communications in both physical and electronic form. In that regard, attorneys must evaluate, obtain, and utilize the technology necessary to assure that their communications remain confidential. And I'll let my co-panelists talk more about that. The other point on competence is, of course, the normal technical legal skills that you use all the time in service of your clients. Those do not diminish just because you may have less time, more distractions. And so I think it's important to continually reflect, self-evaluate, and say, am I able to give my all to my clients right now? And if the answer is no, or if you have concerns about your competence, to figure out ways to work with that. Personally, I have a friend from law school in California who decided she just couldn't do it. She had 2 young kids at home. She was afraid of, letting her work slide. And so she took a 6-week leave of absence because she was really fearful that she would not be able to maintain her competence with all of the distractions and limited time she had. And that's perfectly reasonable and maybe something you can work out if you need to. Moving on to confidentiality, Rule 1.6, comment 2 notes that confidentiality contributes to the trust that is the hallmark of the attorney-client relationship. I probably do not need to emphasize just how important confidentiality is, but the key here is understanding that switching to remote work environments can really challenge a lot of the assumptions we make about security and keeping confidentiality that we often don't have to think about when we're in an office environment. If you are working from home, it may mean that you have less secure networks, your devices are less secure if you're not logging into a VPN. You may have document storage differences from your office. We're now using new platforms where you may run the risk of Zoom bombing or phishing and hacking scams. It may be things that are less obvious, like scattered papers all over your dining room table, and all of a sudden family members and anyone you have in your home can readily see those or look over your shoulder if you're using personal computers. How do you get rid of your documents? Offices typically shred them without you even having to do anything to deal with that. At home, it's a very different story. So you need to be making reasonable efforts under Rule 1.6c to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. The comments there, 18 and 19, talk about safeguarding information, both in holding on to documents in your discussions and communications, and also in transmitting confidential information, all of which can become complicated, as I mentioned, by these new platforms, less formal modes of communication. That same Pennsylvania ethics opinion that came out just recently in response to the pandemic noted an attorney working from home or other remote location is under the same obligations to maintain client confidentiality as you are in a physical office. An attorney's duty to understand those risks and benefits of technology include your obligation to safeguard client information. While working from home, a lawyer must make reasonable efforts to ensure that other members of the household or any visitors thereto cannot access client materials or communications. So those of you at large firms maybe are already getting trainings and communications on how to do this, and you have IT people helping you with this. Those of you in solo practice or who don't have the same resources may need to do a lot of digging to figure this out for yourselves and the best way to safeguard information. A couple notes on diligence and communication. With diligence and promptness, as a lot of you have probably already experienced, a lot of deadlines are getting changed. You may be on different calendaring systems. Staying on top of extensions and rapidly shifting schedules can be challenging. Just make sure that you're upholding those obligations and communicating them to your clients. That leads also to 1.4 communication. This one really can't be understated. Now more than ever, you need to be communicating with your clients to let them know about changes, not just to their cases and things like deadlines, but how do they want to communicate? You know, what are they concerned about with security and privacy? Are they comfortable with you switching to a new platform or a new method of communication? Are you communicating about succession plans or about what happens if one or both of you ends up sick or unable to work for a number of days? It's important to talk about those protocols so that there's no surprises later on. With supervision under Rule 5.1, if you are in management at a firm or if you are directly supervising a junior attorney or a non-lawyer staff member, just remember that those obligations remain strong during this time, even if you're not able to poke your head into someone's office, check in on them, see how they're doing, review their filings. It can be easy to let some of that slide. And for those of you who are junior attorneys or who remember being junior attorneys, it can be very intimidating to proactively ask questions and ask for help because you're terrified that everyone's going to think you don't know what you're doing. So if you are a manager, it is really helpful if you are the one kind of proactively checking in. And finally, some notes on professionalism. In light of the more casual nature of remote work, remote meetings, court appearances, of course, it is still important to dress professionally and use a professional backdrop, particularly when you're appearing in court. Some of you may have seen a news item out of Broward County, Florida, where a circuit judge had to remind lawyers that these are still court hearings. It was not appropriate for a male attorney to appear without a shirt, for another attorney to appear in bed under the bed covers, or to be in poolside attire because you happen to be appearing for the hearing at your pool. In less obvious ones, be careful of things like muting and unmuting, turning your video off and on, background noises, distractions. A lot of you may have heard of the now infamous Supreme Court flush that occurred in the background of one of the first US Supreme Court cases to be heard live. And there's much speculation about the origin of said flush. But it's important to think about, particularly if you have a very small apartment or you live in a noisy urban environment, how you can try to mitigate those things. Hopefully try to keep children, dogs, other, living creatures in your home mostly out of the way. But of course, everyone, I think it's important to keep in mind as well, people are trying their best and we have to have empathy and kindness for one another. Personally, the countertop behind me, just 5 minutes before this presentation, I removed a baby diaper changing station. So I am sympathetic to all of you who are working in less than ideal conditions, maybe don't have home offices and have to lock yourselves in a bathroom to get some peace and quiet. So I think empathy and patience are good things as well. And finally, just a point on vigilance regarding alcohol and substance abuse issues. This has come up often in jest, but it's a serious issue about, not having to go in the office, not having to commute. There's lots of jokes about day drinking. And it's important to, again, self-reflect, check yourself, see if you feel that you may be starting to lose some control over your substance use. And if it's affecting your work, because as we know from Office of Attorney Regulation statistics, substance abuse is one of the biggest causes of lapses in ethical conduct and in problems with following the rules of professional conduct. So just stay mindful of that as well. And with that, I will turn it over to my fellow panelists. Thank you.
Okay, I'm Marc Zwillinger. Thanks for having me. Amie, it's a pleasure to be with you. Melanie, I can assure you that I'm dressed exactly as I would be dressed if we were doing this in person, even though I don't look like John. I'm coming to you from my remote office, which is the Sterling Cooper office from Mad Men. I guess I wanted to illustrate a subconscious point, which is sometimes a remote workplace can be a more ethical one than a real workplace. So I believe in practical advice, so I'm going to take up where Melanie left off and talk about how to apply Rule 1.1 and Rule 1.6 when we're talking about protecting the confidentiality of communications. So I'm going to try to boil this down to 2 questions you should ask yourself every time you're considering the way in which you're working from home or considering whether you should adopt new technology. The first question is, am I putting client information at risk in a different way than I was yesterday, or yesterday being before the pandemic? And I'm not asking, are you putting it at risk at all, right? There's always some risk, and we were using cloud features and other features before the pandemic, but what's different about the risk that I'm taking on now than I was taking on before? And what am I doing to mitigate that risk? And I'm a lawyer, so those are subparts of question 1. Question 2 is, do I have the client's permission, express or implied, to accept that risk? And the subpart is, and where did that permission come from? Where can I point to that I got that permission? And as Melanie said, these questions are based on Model Rule 1.1 and 1.6. I'll just go over 1.6 again. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. That's the part I want to focus on. And I want to talk about how to apply it. And I want to start with the simple and then go to the more complex. So we all talk on the phones, right? Before the pandemic, we had an overhear risk. Some of us would talk on the phones in our office, and there'd be a temptation, you'd be on the Amtrak, you'd be in an Uber or Lyft, you'd pretend the driver wasn't actually there, and you'd go ahead and have a confidential client communication, and you shouldn't have been doing that. But that was a risk that happened in the pre-pandemic world. And now we're not on the Amtrak, and we're not in an Uber. We're having those same conversations in our household with our family. We're going for a walk because it might be beautiful out. We're having this confidential communication while strolling around the neighborhood. Maybe we're in a park, and all of a sudden we have an overhear risk that we were taking for granted, and that we have to think about that certain conversations we just can't have in those places, as tempting it is to go outside if people can overhear it. So let's move from the simple risk, right, the overhear risk, to the interception risk. Before, I might be on my firm network that my IT department was helping me protect, or I might have been in a hotel or a Starbucks or on a hotspot where I'd be worried about maybe I should use a VPN, maybe I should be using my phone as a hotspot. Now I'm on my home network, and I might be using Zoom or Slack or some other method of having these same communications. What am I doing to mitigate that risk? What have I done to my home network? Who's protected that? Have I enabled my router? Do I have a firewall on? Have I chosen a secure password for my Wi-Fi network so my neighbor can't get on it? Right? We have additional risk we're taking on by being at home, and what are we doing to mitigate it? Same thing when we think about storage. Where did I store my documents beforehand? Well, I might have stored them on the firm network or on my local PC or on my phone, or as Melanie pointed out, in a physical space in a controlled office environment. But now I'm storing it on my home network, or maybe on a non-secured PC, a home PC, and then the documents are my home physical space. So all of a sudden I have to be more worried about endpoint protection, protecting those places where the documents are stored. I have to have that firewall. And if I'm picking a cloud service, I have to take certain steps with that cloud service to make sure that I'm protecting the information from data breach. Sometimes the data breach risk is a little bit out of my control. Google Docs is securing it the best way Google Docs can do, and the only thing I can do is choose the right vendor. But other times it is in my control. I can avoid password reuse. I can use a password manager. I can enable multi-factor authentication to make sure that if my password is disclosed in some other data breach, that it's not going to enable someone to get into where I store my client confidential data. So in all of these questions, I'm going back to the same thing. What risk am I taking on, and what am I doing to mitigate it? And that's where you have to have an answer, right? am I just using a consumer grade service, or is there an upgraded version that I can use that provides additional protection? Is there a multi-factor authentication option I can select? Is there a way to do something to reasonably secure against that risk? The other risk I want to talk about is the additional risk of phishing. In the real world, we had some checks against phishing that we would rely on physical interactions to ask somebody, hey, did you send me this email? Or it would be unusual for, I could go down the hallway, I could bump into somebody, I'd have some contact, and now I might not have that anymore. We rely much more on what's happening electronically. Now, Amie sent me the link to this webinar. I clicked on it. It could have been a drive-by phishing scheme. She could have got me in the wrong place, and I didn't have an easy way to call Amie and say, is that the right link? So what do we do about that? Well, we are, as a firm, taking on additional testing to test our employees and train them to avoid phishing schemes. We are running a program either through Phishing Box or PhishMe to test 2 or 3 times a week to see who clicks on these links. We are telling our clients, hey, we're never going to change our payment instructions via email without calling you or texting you or some other way. So don't change our payment instructions and pay us a different way. We're not going to do that. We're also registering domain names that are confusingly similar to ours. So if someone wants to register ZwillGen with 3 L's, they can't then create a Marc at ZwillGen with 3 L's and fool Amie into sending her credentials to that person. We're registering that domain. So we're trying to do these things. And I can't go into all of the things that somebody might do, but I did create a handy dandy slide along with members of my firm and information security group called Crypsis. The slide is posted in the resources group here in the chat. And I'll also share my screen just for a moment to pull it up. But I suggest you click on it and take a look at it. And it has 12 things that you can do to really protect the confidentiality of information that you are sharing on the cloud or in your home network. Just focusing on a couple that I touched on. Point 2 is being vigilant against phishing attacks. Point 4 was using a personal password manager. Point 5 was securing your home Wi-Fi network. Point 9 was worrying about your firewall on your home network. And I didn't touch on this, but making sure your systems are adequately patched so people can't break in is point 11. They're all there for you to look at, and I suggest you do that afterward. I don't want to take too much time reading it to you, but I hope it's a helpful resource. The last thing I want to touch on before I turn this over to John is question 2, client permission. With a wide variety of clients, you may have clients that assert no control at all over how you handle their data, but you may have clients like many of mine where they have absolutely strict protocols. They made you fill out an information security questionnaire. You had to disclose all your uses of the cloud to them as part of the retention arrangement. For those clients, we've already told them what we're going to do and not do in the cloud, and we can't all of a sudden start adopting technology that we want to adopt when we've told them we weren't using it before. So you have to think about, are you violating a promise you've already made to your client, either in the onboarding process or an retention letter or an outside counsel guidelines before you use that technology? The client may have diligenced certain vendors in response to your questionnaire or somebody else's, and they may have a preferred choice. Like if you just ask them, they might say, no, you can't use Dropbox, we vetted that, but you can use Box, or vice versa. But you won't know about those preferences unless you check their outside counsel guidelines or ask. And that gets me to my point about making sure you have consent. You could have express consent or implied consent. Express consent, you've asked them. Or if you do like we've done in the past, we put in all our retention letters, permission to use certain cloud services that we get the client to sign on to for onboarding. We've been doing it for 8 years. But if you haven't been doing it and you're going to onboard a new client in the middle of the pandemic, maybe it's time to put something in your retention letter to let them know that you'll be using certain cloud services. They may have given you implied consent. They may have pointed you to an e-discovery vendor of their choosing. They may have communicated with you via text, in which case you think it's okay to communicate back. But I'd still try to confirm that. And we put in our letters, if you communicate with us using any cloud platform or any method of technology, you are agreeing for us to use that same method to communicate back to you. But I don't want you to glide by client permissions. They can be really helpful. Because if you've made a bad choice in choosing the wrong online vendor, but the client had agreed to it or even recommended it, it's not likely to be a problem. But even if you make a good choice, you think you're doing all the things you should do to make a reasonable choice. If the client disapproves of it and doesn't consent, you might have a problem. So client permission can really help you here, and it's also recommended by a lot of the bar associations. So my final point, and then I'll turn it over to John, is that when you're picking networks for your own internal firm communications, you would think you don't need to go to your clients. We're going to use Slack for our internal firm communications. But you may be using that internal network to talk about client matters. And you may be inadvertently or intentionally disclosing client communications on that platform. So don't think it's just an internal choice. Your outside counsel guidelines, your client permission things all kick in when you're choosing one of these platforms and you're discussing their matters. And with that, my speed presentation, I'll send it back over to Jeff.
Thank you so much. Really appreciate it, Melanie. Really appreciate it, Mark. I will be brief. And I'd like to start hitting on a couple of points that I think build on what Melanie and Mark have laid out for you folks, all of which I think is really excellent advice. The first thing is I want to highlight a couple of specific technologies that either have been mentioned or have been alluded to so far that I think of as being table stakes for making remote work reasonably secure and private. And these are technologies that if you or your firm are not using today, I would really recommend within the next 24 hours, you sit down with your IT people and have a conversation about why not. The first one is a password manager. This is on Mark's slide. And when I refer to a password manager, I don't just mean a password manager that saves your existing reused and low entropy passwords that are based on your pet's name and your mother's maiden name. I mean a password manager that you use to both generate and save passwords that you can then use on your laptop, you can use on your mobile device, you can use on a desktop, you can use it in the office, you can use it at home. Wherever you are, you can use that password manager when you're doing firm business. And that will enable you to have non-reused, high entropy, very long, secure passwords. If you folks are not using password managers of some sort, I really urge you to ask the question why and to rectify that. Because if a data breach occurs and it is the result of password reuse, that is a known threat vector today. And ethics boards and courts and others and clients are not going to look kindly upon that particular happenstance, right? The second one I would say is multi-factor authentication. If you are using services that provide for and offer multi-factor authentication, G Suite, iCloud, Slack, Salesforce, lots of others, it is free and easy to use app-based multi-factor authentication with an app on your iPhone or your Android phone. If you'd like to be fancier, you can actually buy cryptographically secure identity tokens, and those work with Bluetooth or they work with USB and they work in other ways. But the simplest way to get into multi-factor is a simple app for free on your mobile device that will help mitigate some of those phishing risks that Mark referenced. The final thing I would reference is data backups. If you do not have a rigorous and often tested system for backing up data, and not just backing it up, but also testing the validity of those backups, doing a test recovery on a fairly regular basis, you are putting the work of your firm and yourself and your clients at risk. Because when hard drives fail, not if hard drives fail, when they fail, they take data with them. And if that data is routinely and logically backed up and secured, you can get back up and running very, very quickly. If it is not, there's no time machine to go back and enable those backups, right? Good to have good security protocols around those backups. Even better to do the backups to begin with, right? So on messaging, a lot of the conversations that Melanie and Mark mentioned between attorneys and clients and amongst attorneys and at the client site traditionally happen face-to-face. And no record of that conversation will exist. So lawyers can speak extemporaneously, they can brainstorm, They can engage in hypotheticals. God knows all of us lawyers and law professors and law students love hypotheticals, right? And typically no record of those conversations is made from those face-to-face conversations. We need to be transparent and rigorous when we talk amongst ourselves as colleagues, and also when we speak with our clients about the circumstances in which our new video call and audio call future might be recording those conversations. Sometimes there are good reasons to record those conversations. Sometimes there are good reasons to not record those conversations. But in the same way that if everybody looks in the upper left of their screen right now, they see a little red dot and a word that says recording on Zoom. Zoom is a software, and there are others, Microsoft Teams and Cisco WebEx and Google Meet, lots of others, enable recording of these sorts of video and audio communications. And that little red dot and that word that says recording, in my view, is very helpful. But I would not feel confident that it is sufficient if I were recording an attorney-client conversation without me flagging verbally at the beginning, hey, we're going to record this conversation. We all agree to it for a whole lot of good reasons, right? So communicate early and communicate often when it comes to making records of things like conversations that previously were ephemeral, right? Getting away from some of the security aspects and getting into some of the privacy aspects, one thing I would flag is that some systems, Venmo is a prime example, which is used for payment, can be quite secure as far as they go in terms of facilitating financial transactions, but they aren't particularly private. Venmo it creates a public transaction record by default. Some folks think it is similar to PayPal or it's similar to other sorts of bill paying and wire transfers. It's not. It creates public records by default. And there are many clients who the very existence of the client relationship may be confidential. And certainly any notations regarding the services that were rendered and paid for would be viewed as confidential. So be sensitive to privacy risks that are created out there, in addition to security risks. Finally, on professionalism. And I feel uniquely qualified to speak to this topic as the only person wearing a tie on this webcast. No, kidding aside, I must confess, this is the second time I have worn a jacket and tie since we went full remote in response to COVID. The first time was with a meeting of European government officials, and I thought it was a good thing to do. In that meeting, I was the only one wearing a tie. In this meeting, I am the only one wearing a tie. So perhaps do not take my advice on professional attire. But what I did want to do was build a little bit on a set of Melanie's examples and a few things that Marc mentioned. Marc mentioned virtual backgrounds. I have a virtual background as well. This office is not real. If I wanted you to have a slightly more friendly view and a more friendly interaction, I could change it. And we could have a conversation from my house, right? For those of you who do a lot of firm marketing, you can brand your virtual backgrounds and you can remind the folks with whom you chat that you are working at the Future of Privacy Forum or ZwillGen, right? Any of these things. And you could also decide that if you are holding a firm-wide happy hour, you could be a little bit more less professional and a little bit more frivolous with your background. But I really recommend virtual backgrounds to folks. They work in Zoom. There is third-party software that helps them work in other video conference tools. And the reason I recommend it is that having just a stable, static, benign, professional-looking background is the sort of thing that can convey to your clients that you take their issues seriously and you take the conversation seriously. Can cover up a lot going on in your background. And kudos to Melanie for having a real professional background there today. When it comes to interruptions, just a few things for us to talk about as Amie it becomes our interlocutor and our kind moderator here. things that I would float out there, these are real examples that I have personally encountered over the last 3 months when it comes to professionalism. Some of them strike me as totally professional, others sort of on the edge, right? Interruptions. I've been on video calls with folks where there are birds chirping in the background. I've heard dogs barking. We've had dogs and cats join the video call, much to the happiness of many who are involved. We've had family members wander through the background. We've had family members join the video call, ask a question, and then pop out. I have been serenaded with piano lessons and singing lessons from the next room from a family member of someone with whom I was on a video call. When it comes to attire, not a court, but I have experienced a shirtless male colleague by the pool on a video call. That was interesting. I have chatted with a colleague who was in their office wearing far more casual clothing than I'm wearing today. That seemed fine. I've chatted with a colleague who's in their office wearing pajamas. That seemed fine. I chatted with a colleague who was in bed wearing pajamas. That was weird. And I also chatted with a colleague seated in their dining room in a tuxedo, full black tie. Also weird, but, you know, formal, right? So I would just flag to folks that we are living in a new world when it comes to presenting oneself and professionalism and all that stuff. But if you want to convey a certain level of seriousness to your clients, I don't think you've got to go jacket and tie like I did today. I certainly don't think you have to go tuxedo, my colleague Dan. But I do feel like pajamas in bed or shirtless by the pool might be a topic for further review.
Thank you to all three of you. I will say I am feeling a little bit of shade thrown at my BB-8 pillow in the background, and that's okay, Sean. It's there to emote friendliness. In response to Marc, I would never, ever send you my credentials, whether there were 2 or 3 L's in Zwillinger. And back to Melanie, I think that really, really great advice for people showing up to court. One thing that we're actually wrestling with at Silicon Flatirons is the other side of that, letting people know we're comfortable if their kids or their animals come into frame as panelists or speakers or people asking questions, that we're trying to emote a really compassionate environment. So I think it cuts both ways, and knowing your entire surroundings becomes really important. I'm going to encourage participants again to use the Q&A box at the bottom to enter questions. We got one, and Melanie was kind enough to answer it in text, but I'm going to throw it open to all the panelists in case there's more responses. What do you recommend in cases where an attorney is in an apartment with a partner or roommate and they're physically unable to separate or prevent overhearing? Are there consents that should be obtained, or documents or other reasonable mitigation techniques to take on board? I think Melanie provided a lot of really good and interesting advice in the chat, and just to open it up to anybody else who has something.
+1 on the noise canceling headphones. There are technological ways to create space, even if one does not create physical space.
And if that's too big of an investment, but you have a smartphone, a white noise app on your smartphone placed outside the door or near you might have that same effect. I mean, noise canceling headphones are great, but we understand that the expense can be high, so that may be a lower cost way to do it.
Right. And for folks who don't litigate, I know Marc does, and I know Melanie has experience as well, that white noise solution is actually borrowed from federal judges, right, who have white noise machines by the bench. So when they engage in consultations with the attorneys up there, and they would not like the juries to hear that. So perhaps a bit of imprimatur there, that white noise, if at a sufficient volume, if it's good enough for federal judge, it's good enough for private practice attorney.
So there was another question in the background, not in the Q&A, that I wanted to bring up. Sometimes your virtual platforms are not in your control, or they're under the control of grouped parties. maybe 3 or 4 different private practice attorneys want to get together and have one of the subscriptions that were talked about, and one of them remains in control. And that person can then get access to chat records or recordings that the other ones might not have access to. And I've actually experienced this participating in webinars and having to explain to people that chat records can then be made available to the person in control. And they might not want to say everything they want to say in the chat. So could you have recommendations for what happens in those grouping situations, or where you're not in control of all of the information that you're putting into the platform?
I guess let me start with identifying a further problem, and then maybe John and Melanie will have solutions. But it's not just the chat transcripts, but I was asked if a group of small solo practitioners could band together for purchasing power and buy Zoom Pro and make one of them the admin. And in addition to your concern about virtual background control, that person actually had control of all the cloud recordings. So if anybody had hit record to the cloud as opposed to locally, that person would have had access to it, and they get to see the Zoom calendar. And if you put in the calendar invite who you're meeting with, you might have a client confidentiality problem. So group purchasing for some of these platforms is a problem, not just for the control you've talked about, but it is for the control as well, that you need to get together and have a meeting to talk about what those settings would be, because you have to figure out a way to, if you're going to do that type of an arrangement, to protect client confidentiality within those within that setting.
So another one from the Q&A, and John, actually, I might throw this to you, because when you had your initial background on, one of the things I noticed is that you couldn't see your mic, but then all of a sudden the mic came floating into view as if it appeared Harry Potter style. And so the question is, what do you do? What's the problem with virtual backgrounds and floating heads, or just making distracting fade in, fade out techniques that may come up? That you just answered in text as well. Apologies,
for sure.
We overlapped.
No, it's an imperfect technology, and I think folks' tolerances, folks who are on video conferences all the time nowadays, have developed a fairly high tolerance for some of the distractions and some of the downsides of a virtual background. If there are clients who are not often on video calls, they're not corporate clients, they're individual clients. They are corporate clients who don't have I sit on Zoom, or I sit on Microsoft Teams video calls all day, then it can be distracting for them. And then you end up in a situation where you hope that you have a nice professional area like Melanie does. Worst comes to worse, I think a blank wall can look a little institutional in these sorts of situations, and it's not ideal, but it's also really neutral. And I think almost everybody has a blank wall in their apartment or in their home or in their office, and you can just totally take any of the distraction out of it. The other thing I would flag is that the efficacy of these sorts of video virtual backgrounds improves if you go out and get a green screen and toss it behind you. It's really super helpful. But sometimes we're in rooms in the house where we don't have a green screen set up, so it can be challenging.
So I was going to make the same green screen point that you were just making, which is that I do have a green screen, and it seems to solve that problem, because as soon as you go to virtual background, you don't have all that as much of an interference. And it was about $70 investment. Our firm gave all the attorneys $150 to make their home environments better. And I chose to spend my money on a green screen to avoid that situation. So I gave you a little glimpse behind the curtain, but I do think it helps that problem.
So there's another question about password managers as browser extensions. If any of you have experience with the difference between a standalone password manager and a browser extension. And I would actually add on to this. John, you brought up having your password manager on all of your devices. And that, of course, comes with some security give and take as well, because then, of course, it's in the cloud as opposed to stored locally, which you wouldn't be able to have on all devices. What is the ideal way, or what are the ideal considerations somebody should be taking on board when deciding how to operate a password manager and in what form to adopt it?
Sure. So I mean, my basic point, I would love Melanie and Marc's view on this as well. My basic take on this question is that 80 to 90% of the benefit that one gains by merely using a password manager and generating non-reused high entropy passwords is simply gleaned by using the technology, whether it's in the cloud, whether it's stored locally, whether it's on all devices, whether it's only on work devices, just by adopting the technology as opposed to human created passwords that you reuse all over the place. It's just a giant threshold difference when it comes to securing your accounts and your clients' data. Then there are marginal differences in security here in terms of local storage versus cloud storage, in terms of password length, which can vary depending on what you generate and what the site accepts, whether or not the site accepts symbols as well as alphanumeric characters. I mean, there's a lot of detail in there where one could get some slightly greater benefit than the mere adoption of a password manager, right? And using it. Me personally, I think that it's probably good practice to separate work versus personal hardware as a general matter. So that if your personal phone goes missing, it doesn't have a bunch of credentials and apps and other things on there that relate to your client business. You know, it's imperfect, but I think it's possible. But I would be very interested in Melanie and Marc's take. I just think there's so much benefit to using it, whether the passwords are stored in the cloud locally, whether they're whether other options are checked or unchecked. But other views, of course, are out there.
So not hearing a lot of chiming in, I think that was a really great answer and pretty comprehensive for people involved. And I know a lot of times the choice of what tool to use can be deeply personal. And so there's a lot of times in these conversations where people want to ask exactly which tool to use. And so staying away in that top level overview, I think, is really useful so people can make that decision. I want to talk about, we're in a really fast-paced changing environment. Everything seems to be moving and changing almost every day, if at least every week. And so with the uncertainty around this, I think, Melanie, you started with a really great point, that the rules are still the rules and nothing is changing in the rules. But as maybe interpretations change, or I know there was a question that you answered in text about disciplinary action may come out. Are there places or sources that people can go to stay on top of these situations and make sure that they're keeping attuned to any developments as they come about in any of these areas?
Yeah, one I think really helpful resource is to continually check the websites for your state Supreme Court or Office of Attorney Regulation offices. I just looked yesterday and this morning to see if there was anything new, and they put up regular bulletins about changes to court procedures that can be highly relevant for your clients, the way that they're tackling priority amongst cases, how they're handling criminal law issues and juries and things like that, that I think are part of a lawyer's competence to be staying abreast of and understanding, particularly because, as you mentioned, these things can change really quickly. Quick searches in your state, like this Pennsylvania ethics opinion that came out, it seems to be one of the first in the country where a regulatory body has released sort of detailed guidance specifically on this current environment. And so being aware if anything like that is coming out in your state can be really helpful, and making sure that you're following best practices and not falling into traps of, following guidance from a week ago or a month ago, which, as you mentioned, can be really outdated by then.
So I want to get back to the survey that I mentioned at the beginning of the conversation that said that more than 80% of organizations surveyed are looking at supporting work at home and remote work beyond the current situation. And we have some really high profile cases of this, probably most notably Twitter and Facebook saying that they want to provide remote work to their employees as a permanent matter. As the legal profession considers remote work in a more permanent fashion, what do you think are bigger shifts that will need to be made or that you can see coming and should happen in order to accommodate for that? And what should we be thinking about now to make sure that we're in tune with what a long-term solution would have to look like?
So I'll start. You know, I mentioned this during my opening remarks, but managing endpoints is really crucial, right? We had mobile devices and we tried to figure out how we're going to move to mobile devices and how we're going to let people bring their own device to the network. We solved it through mobile device managers, where an organization can institute its own policies on all the devices that are on the network. And so I think ways to secure data, secure communication platforms, more time we have to procure all those things, the safer and more secure the electronic side of remote work will be. I think we have a real concern, though, with disconnect and, you know, attorney satisfaction and substance abuse and all those other things that go without getting together, right? In a family, the old adage is that family dinner is what keeps everybody together. At the workplace, what binds you to your colleagues is that ability to collaborate. So I feel like if we go to an entirely remote environment, we will lose some of the benefits and clients will lose some of the benefits. But I think we can master the tech part of it pretty quickly. We just didn't have a lot of warning before this pandemic. If everybody had said, you have a year to build the best technology you can to then work remotely, we would have done a lot better job of it. And I think that's where we'll be in a year. We'll have had that time. All right, so I went first so I could stall for you, Melanie. You're up.
So my take on this is it's complementary to Marc's. I think firms need to handle this like an IT rollout. There are best practices for doing that. And companies, non-law firms, but companies across the economy do remote IT rollouts all the time. And some firms have done them, right? Some firms have had plans in place over the past decade or so to facilitate more remote work. But as Marc says, not at the scale that we have seen with this pandemic. So give some IT consultants or professionals or in-house folks or outside folks 6 to 12 months to really lock down remote access and VPNs. And this is a priority for us as a firm and as a business and for our clients. And you're going to see some pretty slick stuff that gets rolled out.
I think I'd like to add a point too on perhaps some of the softer side of the professionalism, mentoring, emotional intelligence kind of side of things. And I think, as Marc mentioned, even though a lot of people have been working remotely for a long time, there is something lost without being able to see your colleagues face to face, to check in on them, to have that casual pop-in conversation, particularly in a mentoring capacity. And, you know, there are certainly perks. I think I've benefited from not having a long commute and been able to use that time productively. You know, it may be nice for working parents to get more flexibility, things like that, that make lifestyles easier and better with demanding jobs like all of us have. I do worry as well, though, about the sort of added stress of additionally blurred lines between personal and professional, which there are certainly advantages to that. But as we probably all know, there are some disadvantages of that always on mindset of, well, now, you know, since I can throw laundry in at 11 a.m. in between client calls, it also means at 1 a.m. I could be plunking out an email and people can reach me all the time, 24/7. And especially when you're a junior attorney, it may feel like intense pressure to constantly be checking if someone needs you for something, and if, you know, to never be able to fully relax and kind of unwind. And particularly in this kind of time when there's much added stress and pressure of the pandemic and people's health, that can really create an overwhelming situation. So I think there are certainly pros and cons, and I hope that in the future we're able to realize the benefits of some of the remote push, while maybe maintaining some sort of hybrid where there is opportunity for less formal interaction, or in-person get-togethers, to really have that the kind of benefits of some of that interaction.
Not to belabor the point, but I really Melanie's point about always on, there's a flip side to it, which is that we curate our presentations now, right? And some of the most bonding moments in professional struggles and social interactions at a law firm when you're trying to bind people together is that you interact with people and they're not necessarily at their best, or you see them struggling with an issue, or you're there to comfort them when they've had a bad client call, or they've lost a case, or something has gone on, and you're there, and now we're not. We schedule our calls. We rarely call somebody out of the blue. We schedule the time, we get on the Zoom, we put up our background, we have all that control, and I just think it loses something in the human relationships of what keeps law firms together, and keeps us together as people. But it does have some other benefits as well. But I don't think we should lose sight of that.
Can you dig in a little bit? There's a question on tips for team building and training, and I think Melanie and Marc, you just kind of touched on that a little bit. But do you have any advice for how to overcome this gigantic problem that you've just identified?
So it hasn't been long enough for me to tell you all the things that have worked and have not worked, but we have been experimenting a lot with this at our firm. We've been doing online trivia contests, social games, solving puzzles together. We're a very playful environment, and to try to keep that bonding together, we've been doing a variety of different online competitions and get-togethers to try to solve for that. Everything from maybe doing an online escape room together where you're solving together in team building, to just simple going around the room with a set of questions and everybody answering them. But we are working on that actively. But you can do a lot of the same team building exercises in small groups, breaking out into small groups, then coming back to a big group, as you can do at a retreat when you have breakout rooms online. So we've been experimenting with that over the last 11 weeks.
I think too, we can learn a lot from people who have non-lawyers who have been working remotely for years and years and years. And maybe though some of us aren't familiar or as comfortable with it, like my best friend runs her own business that's entirely remote. Her entire workforce is all over the country. And she's developed some of those techniques to make it feel a little bit more personal that are very in line with what Marc just mentioned. And they'll have meetings where they are not allowed to talk about work for the first half an hour, and they have to go around and talk about either something in their personal lives, or they answer a sort of designated get to know you better question. But where they're really encouraged to be themselves and to sort of be human first, and then build on that kind of trust and camaraderie before they dive into whatever the latest work problem is.
Yeah, I think the one thing that I have learned through this is that folks' life experiences with this pandemic and with remote work are much more varied than I would have expected going into this. And we have folks at my organization who are 1 year out of law school, and they are single and childless and living in an apartment in downtown DC, and they are eager to impress with their work, and they're just launching their careers, and they're super excited about it, and they are just dying for mentorship and learning and all that. And we have other folks at my organization who are well into middle age, who have young children, who have spouses who work, who live in the suburbs, who have a little bit more space to stretch out. They are fairly senior in the organization, and their goal is to help others do their best work. They are not out there striving to impress anybody themselves. They've done that for 20 years or 30 years, right? And it's this diversity of experience that I think we need to figure out, because in many ways, when we all came together in the office for those 8 to 10 hours a day, right, we were on much more even playing fields. And now those playing fields, there's more diversity in them than I think there was before. So good to be cognizant of that and try to be empathetic and raise everybody up rather than, assuming bad intentions if somebody drops off a call abruptly.
So I'm going to turn you all for a parting tweet in closing remarks. So as you prepare what your 180 characters would be, I want to remind everybody we have 2 more events in this series. Next week, we're doing virtual hiring and onboarding. If this current conversation is compelling, to join that conversation next week. And then after that, impacts on startups and an employment law. So that will be the following week, the second week of June. I also want to thank all of our speakers, because we'll end after their little tweets. You guys were wonderful. I really appreciate it. thank the staff and the law IT team for putting this virtual format together. We wouldn't be able to do this without all of you. Thank all of our supporters one more time for making this possible. And we'll start in the backward order from your opening remarks. So John, I'll turn to you, then we'll go to Marc, and then up to Melanie to bring us home.
Be excellent to each other.
That was a very short tweet. You didn't use all your characters. So I have two different directions I wanted to go with my tweet, but don't be afraid to experiment, just not with client confidential information.
I am a bit of a technophobe, not even on Twitter. So I don't even know how many characters I get. But I would reiterate, be kind. And also from the ethics law professor in me, stay aware and cognizant of alarm bells. If you have a slight red flag, little twinge of anything, stop what you're doing, ask for help, look it up, and communicate. And often the best way to sort of keep out of trouble is to just be very aware and talk, and don't go into hiding mode. And I'm sure that I overused my character limit there.
Thank you again so much. And everybody have a really, really wonderful day. Thanks for joining us.